Welcome everyone back to our lessons on contract law. We've been talking about the creation of contracts in these lessons so far, delineating between the first of these major elements, which is of course the concept of agreement. And we've noted that agreement is comprised of two components, these being the offer and the acceptance of the offer. We've so far spent a lot of our time looking at the offer itself, the one side of the equation for establishing an agreement. We talked about the distinction, for example, between an offer and an invitation to treat, and the various pieces of case law that have tried to establish these principles. In this lesson, what we're going to do is talk about the other side of that equation. We're going to talk about the acceptance of an offer. So, ultimately, the other side of this transaction being the acceptance is one that probably merits a little bit more time than we did, or at least than we gave to the previous side of the equation. So we're going to spend quite a few lessons looking at the acceptance in this series before we start to move on to other considerations which form the creation of contracts. So, as a recap, just a quick recap, so far we've been looking at the nature of the offer as forming part of the first step for establishing whether or not a contract exists. The first step is the agreement, and then you also have to have consideration, and you also have to have an intention to create legal relations, and in some circumstances there has to be certain formalities. So it has to be, for example, in writing, although that is not a sufficient or at least a necessary requirement for every single type of contract that may exist. We've looked at the concept of contractual intent, as well as the distinction between an offer and an invitation to treat, and in addition to this, we've also looked at the types of offers which may exist as well. This represents the first half of the agreement equation. We know already that an agreement is an offer plus an acceptance. So we've been looking so far at the first side when an offerer makes an offer to contract to another party. So this is now going to start talking about the next of these components, which is the acceptance of said offer, the point in which we see the other side of the equation make an acceptance of the terms and of the offer to contract by the offerer. So generally speaking, when we talk about the flip side of the equation, when we start to talk about the other side of the process, we're talking about the acceptance of an offer, we tend to follow something known as the mirror rule. Now, the general rule, which is the mirror rule, is that the acceptance of an offer is something which ought to match the offer. Okay, what does this mean? Well, it means that when we look at an offer, we apply lots of different principles. For example, we look at an objective approach as to whether or not an offer existed. We talk about whether or not a reasonable person or a quote reasonable man or a business of business acumen will have understood the facts of a particular case to have been an offer, and we say that this is an objective approach. Well, it means that this very same objective approach that we apply to the offer of a contract has to also exist when we talk about the acceptance of said offer. It should be noted as well that conduct may also be constitutive of an acceptance of an offer. So we will get to that in a second. But ultimately, the mirror rule tells us that we ought to really see the acceptance of an offer in the similar kind of way to how, or at least the process by which an offer is made. Let's look at a case as an example. This is a case from 1877, so a relatively old case of Brogden and Metropolitan Railway. The facts of this case are as follows. The defendants had supplied a railway company with coal without there ever being a formal contract in place. The railway company were the claimants and the defendants were the suppliers. There was no contract in place to do so, but it was just a sort of general agreement that had existed between the parties for the claimants or for the defendants, should I say, to supply this railway company with coal. There had been a draft contract sent by the claimants, by the railway company, but no real formalities had taken place. So that a draft contract had been sent to the defendants, but ultimately nothing formal had taken place. No signatures, for example, had been made, and in addition to this, they just sort of carried on with their arrangement of supplying coal to the railway company. This was a process, by the way, that went on for up to 2 years. So draft contract was sent, nothing formal had taken place, and then as a process for up to 2 years, there was just this supply of the coal to the railway company. When the defendants then decided to cease the supply of the coal to the claimants would sue for breach of contract. But you might be thinking, well, they never actually signed a contract. There was no formal contract being in place. There was a draft contract that was sent out, and there was sort of the following of the terms of the contract in the supplying of the coal, but there was never any kind of formalities that had taken place, no formal signatures, for example. So the question here was whether or not there was a contract between the defendants and the railway company. And it was held that there was a contract because the acceptance of this contract was stipulated by the conduct of the defendant. So rather than actually signing the contract themselves, essentially what they had done was they had been given an offer to contract by the railway company in the actual draft contract itself, and then they had just simply performed the terms of that contract. And it was this performance and the conduct of the defendants that constituted the establishment of a contract that existed. The acceptance was stipulated by the conduct of the defendants, and the defendants were in breach of that contract by ceasing on a whim to supply the coal. It was found that where there is a draft contract, and that the parties have acted upon this draft contract by acting in accordance with its terms, they can become bound by said contract. So when I said in the previous slide that it should be noted that conduct may be constitutive of an acceptance of the offer, this is a good example of how this operates. Because what they're saying is there was no formal signing of a contract in the way that an acceptance could be established, but instead there was the performance of the terms of a contract that was a draft contract, and therefore this almost legitimizes the draft contract in question because of the fact that they had acted in a way which performed or was in accordance with the terms of the draft contract that was sent out. In our continuing discussion of the idea of creating a contract and firstly establishing an agreement between the offer and the acceptance of the offer, I want to talk about one of the things that sort of sits in the middle between these two different concepts, between the concept of offering and accepting, which is this idea of a counteroffer. And the idea that a negotiation ultimately entails not the refining of the original offer, but in fact the returning of an offer that is countered by the person who is receiving the original offer, if that makes any sense at all. We'll get to what this means in a second. So ultimately, the way the law understands the counteroffer within the law of contract is that essentially it recognizes this mirror principle that exists within the idea of agreement between offering and accepting, which is essentially telling us that the acceptance of the offer must balance that of the offer itself. There must be a balance. You have to accept everything in terms of what is offered. You have to accept the terms that are offered. This therefore means that if you are going to accept an offer that is made to you, you have to accept the offer at the terms which are sent and in the condition that it is sent at. And so as a result of this, if you were, for example, to try and change the terms of the offer and then make an acceptance on the basis of this, you are not accepting a modified offer. You're not making a modified acceptance of the original offer. What you are doing is making a counter offer instead. So if, for example, somebody offers to contract with me for a particular agreement and they have a set of terms, in order for acceptance to be valid in terms of that particular offer itself, I have to accept all the terms. I have to accept it as it is stated, as it is sent. It's supposed to reflect that. The acceptance ought to reflect that of the offer. But if I decide, you know what, some of these terms I don't particularly like, I don't particularly agree with this term and this term, I'd like to negotiate this, I'd like to turn these terms down or maybe modify them in a way, and then once I've done that, I'm going to accept that offer. That isn't actually accepting an offer. Instead, what that is doing is making a counter offer back to the original offeror, who is going to have to then accept the counter offer. And so it means that the negotiation of contracts, depending on the type of contracts, the complexity and the back and forth that may be had, may actually involve a multitude of different offers and counter-offers being presented by each of the parties to each other. And ultimately, in this particular area, the most authoritative and leading case on this issue of counteroffers is the case of Hyde and Wrench from 1840. Now, in this case, the defendant had made an offer to sell his farm to the claimant. So D makes an offer to sell a farm to C. This was for the price of £1,000, which in today's money is a lot more than £1,000. In reality, if we were to sell a farm for £1,000 today, that would be a particularly good deal that you could get. But in 1840, £1,000 was a lot more money than it is now, and so the selling of a farm for that is seemingly reasonable. So this is the original offer. This is the offer that is made. The defendant has said, I'm going to offer you this farm for £1,000, and the claimant then responds. They went on to make a counteroffer. They said, well, how about I sell the property, buy the property off you for £950 rather than £1,000, trying to negotiate the price down a little bit. Now, when the defendant refused this at this price, the claimant then went and said, okay, then, well, I will accept the original £1,000 offer. That is the kind of sneaky little negotiating debate tactic that was done in this particular case. They said, well, what about 950? No. Okay, then, well, I'll accept 1,000. And at this point, the defendant then refused again. They said, well, no, you tried to counteroffer me, you tried to lowball me, if you will, for 950. I'm not going to now sell you the property for the original price of £1,000. I'm going to go elsewhere and sell it to somebody else. Well, at this point, the claimant then sued for breach of contract. According to the claimant, the defendant had made an offer to sell the farm for £1,000, at which the claimant had then accepted. There was a little bit of a back and forth in the middle where there was this potential of selling the property for £950, but when this was refused, the claimant went and said, okay, well, I accept the original offer, and therefore a contract is made, and a contract is therefore valid. That is the argument that the claimant made. Now, it was held in the courts that there could not be a successful claim for breach, since there was never an original agreement. There was an original offer, but this original offer was never accepted. When the defendant made this £1,000 offer originally, this offer was destroyed when the claimant tried to make a counteroffer, and so the £950 offer, on the other hand, by the claimant back to the defendant, was actually the thing that negated the original £1,000 offer. And so, as a result of which, when that was then refused, it means that there was no offer at all on the table. There was no valid offer, and therefore no valid way you can accept said offer and form a contract. According to Lord Langdale, the plaintiff made an offer of his own to purchase the property for £950, and he thereby rejected the offer previously made by the defendant. And the general rule of thumb here that is established is that if you try and make a counteroffer, you are implicitly rejecting the original offer. And so at that point, that original offer is gone. And it is up to the defendant, in this case, the offeror, to make that offer again for you to accept it. You can't then go back and say, actually, this offer that you originally made was an offer that I'm going to now accept. And so that's what happened in this case. Simply put, you cannot reject an offer that is made and then try to accept it as soon as your counteroffer is also rejected. That doesn't seem to be particularly fair, and this is essentially the established law relating to counteroffers. Welcome back, everybody, to Contract Law. In this lesson, we're going to continue to talk about the creation of contracts, focusing on this idea that is often cited within the commercial and business area of contract law, which is obviously where quite a lot of contract law is established, talking about something known as the Battle of Forms, or the Battle of the Forms, which sounds like a historical medieval combat situation, but in reality is a particularly interesting element of negotiations when it comes to making offers and acceptances in relation to contract law. So we'll talk about the concept of the offer and the acceptance in the context of business and commercial negotiations, and this is often known as the Battle of the Forms or Battle of Forms, which is a general legal principle, which is or at least an approach which is attempted to be established by the courts when it comes to looking at commercial contexts in which standard form contracts may be used, and where there may be multiple standard form contracts which are essentially trying to win out over the other. And we'll see what all of this means with reference to some case law as well. So, one of the things that is a reality within commercial law, or within the sort of general business sector more generally, is this idea of a standard form contract. So in the context of commercial and business law, the growing use of standard form contracts refers to a simple model contract which is given as a standard template for business arrangements. In a lot of businesses and a lot of different contexts, there may be lots of contracts that are signed. And so for simple ease and basic standards, a business may opt to create a model standard form contract that they will utilize, and they will be able to essentially reproduce and replicate and duplicate for various different business arrangements. It's a general and standard practice when it comes to contract law in commercial contexts. And ultimately, where there are, say, for example, two companies that are both looking to enter into contractual relations with each other, and where they both utilize standard form contracts which have various differences, there has been a need to clarify the position of the law in these circumstances. And so given the fact that businesses want to utilize their own standard form contracts, it will make sense to suggest that something of a battle of forms will take place. So ultimately, to set the stage for what battle of forms refers to, you have standard form contracts, a standard model contract that may be used, that may include specific terms that are required for various different businesses. If there are two businesses that both use standard form contracts, and these standard form contracts are different, which one will win out over the other? Where there are such disputes arising in contracts which have these kinds of standard forms in terms of their structure and in terms of what's included, the courts will have developed a number of different principles. The first of these principles is known as the last shot principle, and the last shot principle suggests that the party in negotiations who introduces their standard terms last are the ones which will prevail in a case of a contractual dispute. So if you have a lot of back and forth, a lot of negotiations, lots of offers and counter offers going on, the ones who introduce their terms last and therefore have an acceptance of those terms and a contract is established, those will be the ones that are going to prevail over any of the others in a contractual dispute. Essentially, what the last shot principle tells us is the person who fires last will get the edge in a standard form of contracts. And so we can have a look at this by looking at some of the case law. And one of the cases that is really, really important for this particular area is the case of Butler Machine Tool Corporations Limited and the Excello Corporation from 1979. Now, in this case, the main issue involves something known as a, quote, variation clause. Now, variation clauses may exist in various different contexts. In this context, the variation clause essentially allows the seller of the machines to increase the price of the item as the cost of that item increases. So maybe they have a standard point at which they sell, but with the variation clause, they may say, well, we'll sell it at this price, but if the cost of the item increases over time, then we will add this cost on to the final cost of the item under this variation clause. The claimant had included such a variation clause in the contract to the defendant. This was a standard form contract. However, the defendant would then submit an order for such a machine to be used, and they used their own terms and conditions in the submission of this order, their own standard form contract. And within this standard form contract, there was no variation clause. Okay, so there's this sort of general variation clauses in the standard form that is submitted by the claimant. The defendant then submits an order for a machine, but they submit an order under their own terms and conditions, their own standard form, which does not include said variation clause. Now, Ultimately, the defendant had included a slip which was to be returned by the claimant, stating that they had agreed to the terms and the conditions which were cited therein, i.e., the terms and conditions which were sent by the defendant. So they submitted an order, they included terms and conditions, and they said, please return these terms and conditions as an indication that you accept these terms and conditions. Now, the correct thing to have done, if you were the claimant in this case, was to reject the terms and conditions, because you would have said, we will sell you these machines, but we want to sell these machines under the terms of the contracts that we establish, not the ones that you have issued. But instead, they actually, the claimant just signed and returned this slip, which therefore meant that they had essentially bound themselves to the contract that was established by the defendant, not by the claimant. So litigation would, of course, begin when the claimant sought to implement their variation clause, which is in their contracts, but the defendant would refuse to pay said variation clause because the variation clause isn't in their contract, as it wouldn't be. And it was therefore held which contract was valid. Was the variation clause valid? Was the litigation valid in the first place? It was held that the claimant had no claim to increase the price under their own variation clause, despite the fact that the claimant had fired the last shot by returning the slip. They had returned the slip, which was the defendant's contract. Okay, so despite the fact that they had fired the last shot, is irrelevant essentially, because what they had done is fire the last shot by accepting the standard terms of the defendant's contract, and this did not include a variation clause, as a result of which they could not make a claim that there was a variation clause in the first place. A far more recent case, which was actually quite groundbreaking, in fact, it was in 2021, was the TRW Limited versus the Panasonic Industry case. What this case illustrates is the view that the first shot, which could be established at the beginning of a negotiation, may apply over the last shot in the Battle of Forms, where there is a pre-agreed set of conditions. So there is certain circumstances in which the last shot is not the general rule that is applied. In fact, the first shot may apply. This is assuming you have a negotiation process which takes place where it is established at the beginning the pre-agreed set of conditions. Like, for example, we are going to agree to this, this, and that, and these are going to be the standards. This is going to be essentially the fundamental agreement that we're going to build our negotiations on, and then they may negotiate back and forth. And in those kinds of cases, it is understood by the court that those pre-agreed set of conditions ought not to be essentially overruled in application of the last shot principle. So the facts of this case are as follows. The claimants in this case had brought a set of resistors, or at least a batch of resistors from the defendant, Panasonic. And this was a pre-established and long-lasting relationship between each of the partners, so this wasn't the first time there had been this purchase. And it included a set of general conditions which had been established with the intent on both sides of negotiations to keep these conditions regardless of the subsequent negotiations. So there may have been negotiations back and forth, but at the beginning of the negotiations, these general conditions had been established automatically. These are the basic fundamental agreement that we have. Let's now negotiate further into the sale of these particular items. One of the legal issues arose around the jurisdiction of a case, of the case itself. The general conditions that were established previously stated that the jurisdiction for proceedings would be in Germany. So they said at the beginning of the negotiations, the jurisdiction for if any legal case was to arise would be Germany, no other jurisdiction would be valid. And so when the claimant sought to make a claim in England on the basis of one of their standard form conditions, which had been subsequently established, the defendants argued that there was no jurisdiction. Now, given the facts that are established here, if you were to apply the last shot principle, however, the idea that the parties that fired last are the ones that prevail in terms of their standard forms, you may make the argument that it would be valid that England would have jurisdiction. And so as a result of which, the last shot principle would apply and find in favour of the claimants. However, It was held in this case that Germany had the proper jurisdiction, and so therefore the appeal was dismissed. There was no jurisdiction in England. And the reason for this was, if you are going to agree to early negotiated conditions, which both sides understand will continue throughout the negotiation of new terms, it was understood by both sides of the agreement that these early foundational conditions would not change regardless of what other terms would be introduced. It is the first shot which would apply rather than the last shot. In this lesson, what we're going to do is talk about the method of communication when it comes to an acceptance of an offer in contract law. And we're going to begin by focusing on this idea of the postal rule, which is something of an archaic and potentially not that useful use of the Royal Mail these days, especially given the fact that contracts are formed in far more electronic and far more instantaneous methods. But the postal rule was very, very important for a very long time and was justified on a very interesting basis. So we're going to examine essentially the first rule in relation to the actualizing of an acceptance of an offer. Because one of the things that we're going to learn and that we're going to look at in future lessons is this idea that in order for the acceptance of an offer to be valid, and for therefore an agreement to be valid, and therefore for a contract to be valid, assuming the other factors like consideration are also present, you have to be able to communicate the acceptance of that offer to the offeror, which seems to be something of a simple thing to understand and relatively obvious, but there are examples and cases where people have tried to argue that silence, for example, and no returning communication of acceptance could still validate the existence of an offer, or an acceptance, should I say. All of these things are going to be important to examine, especially when we look at the postal rule. Essentially, when we're asking the question of when an acceptance of an offer is sufficient for a contract to then be in operation, we have to think about one of the earliest principles, which is this idea of the postal rule. It's sought to regulate this area of the law. Now, ultimately, what the postal rule does is provide an exception to the view that in order for an offer to be accepted, it must be communicated to the offeror. So in today's understanding of contract law and in the original understanding of contract law from the sort of early beginnings, there was this view that if you are going to accept an offer and for that acceptance to be valid and for that acceptance to be actualized and therefore for a contract to start and to begin, the question is the offeror has to have been communicated that the offer that has been accepted. Now, what the postal rule does is provide something of an exception to this view, because under the postal rule, there is not this need for the communication of to the offeror. The offeror does not need to know that an offer has been accepted for a contract to exist. The effectiveness of the acceptance will be determined on the basis of whether or not it has been made clear to the offerer. But what the postal rule does is provide an exception to this principle. What this essentially does is tell us that when it comes to postal acceptances, so when it comes to an agreement that is formed via the post, the acceptance will be valid as soon as it has been posted, not as soon as it has been received. So it could be the case, and it was the case very many years ago in the 1800s, for example, that post was a lot slower than it is today, and that it may take multiple days for a letter to arrive. But it's as long as that has been posted, as soon as that post has it gone into the letterbox and has been put into the Royal Mail system, then it has been accepted, and the acceptance is valid. The authority of this, the leading authority, is the case of Adams and Lindsell, from 1818. So a very, very, very old case. And this is why some textbooks spend quite a lot of time talking about the postal rule and talking about a lot of the implications of the postal rule. Other textbooks don't, because of the fact that in today's modern contractual understanding and contractual contexts, the postal rule isn't as important as it used to be. But we'll talk about it in this lesson, and if you want me to go into more detail in future lessons, then just let me know. So the case of Adams and Lindsell from 1818 was a case involving the following facts. So the defendant in this case had sent a letter to the claimant. The letter had contained an offer for the sale of wool. Now, the claimant received the letter on the 5th of September, and would respond with an acceptance on the same day. So the offer of wool was sent, it was received on the 5th of September, and an acceptance of this offer was sent back on the 5th of September, that very same day. But of course, it would take a few days for it to arrive, given the fact that we're in 1818. It would take 4 days, specifically, for the letter to arrive back to the defendant, at which point the defendant had thought, well, this person clearly doesn't want the wool, or this person, or I found another person who I would rather sell the wool to, and so had already sold the wool to a third party. So the letter was sent back. It was sent on the 5th of September. It was received by the defendant on the 9th of September, but on the 7th of September, a couple of days prior, the wool had already been sold to a third party. So we have a bit of an issue here. The claimant was, as you can imagine, quite annoyed at the fact that they had sold his wool that he had accepted, and he had accepted this wool on the 5th of September owing to the postal rule, which we'll get to in a second, and so sued for breach of contract. The argument was, the defendant argued that owing to the fact that no acceptance was communicated, there was no contract, and so therefore when the wool was sold on the 7th, there was no contract, because he only received communication of acceptance on the 9th, which was a few days later. And this would traditionally fit into the ordinary meaning of the basic rules of contract, that an acceptance has to be communicated back to the offeror. But the postal rule applied in this situation. In fact, it was established in this situation. The defendant was in breach for selling the wool to the third party, and this is because acceptance of the contract was valid as soon as the acceptance was posted, despite the fact it hadn't been communicated to the defendant at all. So if we go back to the original facts of the case, the acceptance of the offer was valid on the 5th of September, the day the letter was received, because it was the day the letter of acceptance was sent. And so therefore, even though it took 4 days for the letter to arrive back into the hands of the defendant, on the 9th, it was already accepted. And so as a result of which there was a contract which was then breached by the fact that the defendant sold the wool on the 7th of September to a third party. And so this established the principle of the postal rule. And so while one of the most important elements of contract law relating to acceptance of contract, the postal rule appears to be something of an outdated principle. This is why I'm not going to spend too much time on it, and ultimately we're just going to begin and end with the postal rule in this video. But if you want me to go into more detail, as I've said, then feel free to comment down below. Of course, there are lots of reasons why the postal rule isn't as important in today's modern contractual context. Firstly, the Royal Mail makes deliveries far quicker, so it doesn't often take 4 days for a letter to arrive anymore. It often will take 1 or 2. Nice. This means that this idea of this big time gap in which the acceptance is valid but is not communicated is a lot smaller in most cases and most circumstances, so this lowers the risk of being able to sell the property to a third party having not known about the communication of the acceptance. But the more important reason why the postal rule isn't as valid is because the vast majority of contracts these days are probably not made by post, by the Royal Mail, by letter. They are performed often by electronic communication, which is potentially instantaneous. So if I'm making a contract these days, I'll often do so, if I ever make a contract these days, I'll do so by email, for example, or even by text. These are things which are instantaneous, potentially instantaneous. And so as a result of which we have to think about a whole new set of laws and principles of law relating to how we apply acceptance and communication of acceptance in circumstances where we have digital communication of acceptance rather than postal communication of acceptance. So one of the principles which is established by the postal rule is this idea that it must be used reasonably. So one of the things that is important to note is that if you're using the postal rule or even weaponizing the postal rule against a particular party in a contract, then it would be invalid. So if the offeree, for example, knows that there might be a significant delay in receiving of post, then it may be argued that the use of the postal rule would be unreasonable, and they would be using it for unreasonable means and therefore not valid. So for example, if there was a contract in place or at least an offer that was made by post, and this the offeree, the person who is supposed to accept this offer, isn't a particularly nice individual, knows that there's going to be a postal strike the next day that's going to last 2 weeks, for example, and they make sure that they delay the posting of their letter of acceptance until the day of the postal strike, so that there's going to be a massive long delay, then it doesn't seem to be particularly reasonable to apply the postal rule in this regard, because in that case they would have been deliberately done so in this way, and it would have led to a situation where a valid acceptance and therefore a valid contract may exist for up to potentially weeks without the offeror knowing about it. A good indication of this is the case of Holwell Securities and Hughes from 1974. This case establishes the principle that the postal rule, in fact, can actually be disapplied in certain circumstances. And it can be disapplied in certain circumstances, one of which is a circumstance where the offerer makes it very explicit that they want to disapply the postal rule. So, for example, in this case, an offer was made between the defendant and the claimant to purchase some land, and Clause 2 of this offer included a provision in which stated that the offer must be exercisable by notice in writing. Now, the potential purchasers would send acceptance by writing, but this would never actually arrive. And so the arguments that were had here was that, by the claimants at least, that there was an acceptance and therefore a valid contract owing to this idea of the postal rule. But it was held that it was not valid owing to the fact that the postal rule had been excluded by Clause 2 of the offer. So if the offer explicitly says, I want you to return, if you accept these terms, or you accept this contract, you need to accept this contract in this form by this date, for example, and this form excludes the postal rule, then the postal rule will be disapplied. So if I make an offer to somebody for a contract, and I say in the offer that the acceptance of this offer must be done by email or any other kind of digital electronic communication using these different ways of and methods of communicating me, and I instead receive a letter in which the individual is trying to utilize the postal rule, that may and almost very likely will disapply the postal rule, because the offer itself made it very clear that there are specific ways in which the acceptance of the offer ought to be communicated.